Hi, and thank you for joining this webinar about the General Data Protection Regulation and the roles and responsibilities of controllers and processors, and specifically the relationship between controllers and processors. So my name is Mark Gracie. I am founder of Flavorify Digital, which is a data protection consultancy, and the Digital Compliance Hub, which is an online support service. And I'll talk a bit about what Digital Compliance Hub is towards the end, and certainly how it can help you with your compliance in this particular area, or indeed anything to do with GDPR or e-privacy. So before we sort of get down to the details of what's actually involved in the controller processor relationship and what the law requires in terms of its specifics, just a quick background session about some of the key things to just bear in mind, and just to remind ourselves of what the context is behind this controller processor relationship. So if you're familiar with GDPR, which I hope you are, because it's been in place now since the 25th of May last year, so what's that, that's 8 or 9 months now. So this fan diagram is one I used a lot last year to sort of highlight the key 10 areas that are changing with GDPR, and this particular session is about the controller and processor relationship, and that was one of the key changes that was introduced in the GDPR. But just taking a step back to data protection and what the key definitions and what the roles and responsibilities are in terms of, sorry, not roles and responsibilities, the key definitions and who the key players are in data protection terms, is just worth reminding ourselves of what data protection is about. Of course, data protection is about the compliance and the protection of personal data. So that's any data that enables you to identify an individual, either directly, because it clearly is that individual's data, or indirectly. So what that means is if you have multiple pots of data and one pot has not got any specific personal data in it, but it has an identifier which you can use to tie in with some other data that is clearly personal data, then it makes both pots of data personal data. So if you can identify an individual, then it's personal data, and data protection applies. And that doesn't matter whether you're dealing with your customers' data, your employees' data, your business contacts, your suppliers' data, or whatever. If it's an individual, can be identified, whether in their personal life or as an employee of a business, it's covered by data protection. Now, everything you do with that data is referred to as processing. And this is very key, particularly for this topic that we're talking about today, because processing covers everything that you're doing with that data. So it's not just why you've got the data in the first place. It's not just so that you can perform on a contract that you've entered into with your customer, or in terms of offering employment to a new recruit or an existing employee. It is everything. So it's storing, it's editing, it's deleting, it's manipulating, it's sharing, everything you can think of that you might do with the data, then that is referred to as processing. And of course, we have the three key actors when it comes to data protection. You have the data subject, who is the individual whose personal data it is that's being processed. The organization that's collecting that data from the data subjects and determining how it's going to be processed is referred to as the data controller. And the data controller may outsource or require the processing of their data by using a third party, and that third party would be referred to as a data processor. So in a very simplistic marketing model, you, as the data controller, collect email addresses from your contacts. Those contacts are the data subjects. You're collecting that data and going to be determining what you're going to be doing with that email. So like email marketing, for example, that makes you the controller. But if you pass those email addresses to a marketing company to actually send out the emails for you, that makes them your data processor. So it's quite important that you understand whether you're a controller and a processor, and in some circumstances, without getting into too much of the complications around determining it, you might be a controller and a processor, and certainly some processors will be controllers for particularly their own data, for example. And other types of processors may, even though they look like they're a processor, might actually be a controller, because they are determining what's going to be happening with the data. But at a simpler level, the controller collects the data from the data subjects and determines how it's going to be processed. A processor is a third party the controller is using if they wish to have their data processed for them. Now, in terms of what the GDPR says and what the UK data protection law says is basically covered by what's referred to as Article 28. So this is a specific article in the General Data Protection Regulation that sets out that two key things when it comes to the controller and processor relationship. Excuse me. Firstly, controllers can only use data processors as if those data processors are compliant. So what that means is that you shouldn't be using, if you're a data controller, you shouldn't be using a third-party processor unless you're absolutely sure that they are themselves GDPR compliant, because by relationship, if they're not compliant, then you're not going to be compliant by using them. So there's an element of due diligence that has to be carried out. So checks and balances have to be put in place to make sure that you are using third-party processors who are indeed GDPR compliant. Then secondly, Article 28 requires a very specific list, and we'll talk about the specifics a bit later on, a specific list of terms that need to be in a contract between the controller and the processor. And those are usually what you would see in a data processing agreement or a data processing addendum or in a terms of service or a contract in terms of business. And they are basically saying that the data processor will process data according to a set number of terms. As I say, we'll talk about what those terms actually mean in detail in a bit. So those are the two key things. Don't use a data processor unless you're absolutely certain they are compliant. And when you do engage with them and they do your processing, you've got to make sure you've got a contract in place, be it a data processing agreement or whatever term. It doesn't matter, but there are specific things that have to be in place in that agreement or in that contract. So moving along, if you're a data controller, what does this actually mean? What does the compliance look like for data controllers? Well, because of the due diligence, you're going to have to make sure you understand who your processors are. And now the key thing here is to understand that wider definition of processing. Remember that processing covers such a wide number of different things you might be doing with that data. So if you're using a third party who's clearly processing your data for you, then there's a good chance they're going to be a data processor. If you're using a third party service, maybe you're using a customer relationship management system like a CRM, like HubSpot or Salesforce or Zoho. Those are cloud-based services that are processing your data by the mere fact that you're putting personal data or contacts, if it's a CRM, for example, onto their service, and that makes them a third-party processor. You may be storing your data on cloud-based storage or with another party. So, for example, if you have an Excel spreadsheet with all your customer records in, and you store that on a Dropbox or a OneDrive or some other kind of storage, or if you email it to somebody to look after it for you, they are all circumstances by which they would be considered third-party processors, so would be data processors. And then you've got this other group of people who you aren't specifically asking to process data, or they're not a service that enables you to process data via their service, but they might have access through some services they offer to you to your data. And that doesn't necessarily mean that they're a data processor per se, but for the purposes of when they may incidentally access your data, then you may need to make sure that they are fully aware and they are compliant. Because I mean, a good example is an IT support service. So IT support services, you pay a regular subscription for somebody to come and fix your computer, or maybe a piece of software that you run on your systems at your workplace. And those support people, be they IT, be they software, may have access either directly by coming into your office and accessing your computers and your systems, or remotely because they supply the service at a distance. But if they are using your services, and they can take control of your computer, or they go into the software that's got your customer records in, they will have access to your data, not because they need to, but because they just happen to by providing the service to you. So, for example, you've got a piece of software, you use that to store your customer records. It doesn't work exactly how you want it to work. You've got to show it to a software support person. That software support person is going to see the personal data. And it's important to understand also why the wider approach to what is authorized and unauthorized access. And that's why I bring that into this bigger picture about knowing who your processors are. You might be engaging services for people who incidentally might access your data, and you need to make sure that they're compliant as well. So not quite so strict in that particular scenario as opposed to actually data processors, but you will need to, it's probably good practice to consider thinking about them and also how you can put those controls, and particularly a contract in place that basically says if you do accidentally come across our data while you're servicing my computer or you're doing what I've asked you to do, just make sure that you abide by data protection law. Excuse me. So first up, know your processors. Make sure you've got a good understanding of who it is that is your data processors. Hopefully you've already done that, because you need to understand what data you have and how it's being processed, and in relation to that you should therefore know who your processors are. So hopefully if you're already been through the GDPR audit and understanding where things are, then you've already got that all documented anyway, because you need to have that documentation in place to be able to demonstrate your compliance. But regardless, know who they are so that you can identify what you need to get put in place. The next thing to do is find out what they say about GDPR. They may already have statements and positions, privacy policies, a set of work that they've carried out to ensure that they're compliant, already available to you to access. They may have supplied that to you. They may have pointed you to it on a website. At a very basic level, go to Google, search their name with GDPR and see what comes up. Some organizations are all over this, so you'll find that information quite easily, and they'll answer all the questions that you need to have answered, so that'd be really good. But there are also a lot of out there who think all they need to tell you is that they've got a privacy policy. Well, a privacy policy is something completely different, and isn't for the purposes of the controller-processor relationship. Is to meet the requirements to the right to be informed for individuals, so everybody knows where their data is being, how their data is being used. So if somebody says, look at my privacy policy, that covers everything, don't just rely on the fact that they've got a privacy policy as an example of their GDPR compliance. You want to know a bit more detail about that. And then finally, the key part really, because this is really the thing that needs to be in place, is the contractual element. Do they have agreements or terms of service or something else that they've asked you to sign or agree to by the use of the service that covers the legal contractual requirements that have to be put in place between you as the controller and them as the processor? And again, you know, if you go to that second step of sort of finding out what it is that they say about their GDPR compliance, with a bit of luck, they've actually explained that, you know, by using the service, you've got to abide by our terms of service, and there's a data protection section in those terms of service which sets out exactly what we'll do and our obligations, and meets the Article 28 requirements. Unfortunately, as I say, not all processors are all over this, which is surprising given that it's 8 or 9 months since GDPR came in, but different people have different views about how they have to meet this requirement. If you can't find the information you want, or they don't have these agreements in place, you're going to have to contact them directly, and ideally you shouldn't be using their service until you've got all these checks and balances carried out and that you've carried out this due diligence. So, you know, whether you use a templated questionnaire to ask them how they deal with sub-processors, how they deal with deleting data, how they deal with breaches, how they're going to help you, and all these kind of things, which are all the contractual terms, which will come on in a second, is up to you how you do it. But you shouldn't be using their service unless they can demonstrate that they're compliant. You shouldn't be using their service unless there's a contract or an agreement in place that meets the contractual terms. If you can't find what you're looking for, you're going to have to go to them direct and ask. And I know from personal experience of working on behalf of clients dealing with these kind of issues that sometimes it can be quite laborious in trying to get the information you need out of the business. They think that they're compliant. You're pointing out that they're not answering your questions and not addressing everything that you need to have addressed. And there's a bit of toing and froing, and in the end you might need to throw at them, this is my data processing agreement. If you want me to use your service, use this. Of course, sign this. Of course, if you're using sort of household names, the Googles, the Microsofts, the Salesforces, the HubSpots, etc., the MailChimps, they all have data processing agreements. They all have a lot of personal data and GDPR compliance information on their website. So If you're using I guess, bog standard third-party services who are your data processors, there's a good chance you're not going to have much of a challenge. But depending on what you're doing and what services you're using, there's a good chance you might have to come up against some people who perhaps haven't quite got it quite right, and you're having to challenge them and make sure to do it. And of course, it's up to you to be able to demonstrate, because of the accountability principle in GDPR, that you are compliant. So you need to be able to demonstrate that you've got them to jump through these hoops of compliance, regardless of whether you think they're compliant or not. You've got to demonstrate that you think that they're compliant. So first step, carry out your due diligence. And an element of that step is basically determining how you're going to get these contractual obligations in place. Now, in terms of the contractual obligations themselves, I've summarized here the key points. So these are things that are actually on the face of the legislation. And what that means is the law actually dictates that these terms have to be in place in those data processing agreements, that the contract or whatever terms of service or whatever that you might be agreeing or putting upon your data processor, these terms have to be in it. And what they basically say is the data processor must, firstly, only process the personal data on the documented instructions of the data controller, only process the data outside the EU if the controller agrees, and where they're able to demonstrate that they've got appropriate checks and balances in place. So if you're not sure what I mean by that, remember that it's unlawful to process data outside the EU unless the country in which the data is being processed has adequate or equivalent data protection in place. And there's some checks and balances that have to be put in place. Either the EU has said that they've got equal data protection in place. So Japan, for example, has just been given an adequacy agreement, so you can process your data in Japan without having to worry about GDPR compliance, because Japan has an equivalent set of data protection laws. Or if it's in the US, that the company you're working with has got is a signatory even to the Privacy Shield, which is an agreement between the EU and the US, or that there's some other kind of model contract clause in place, which again is a set of terms that's dictated as to what needs to be in place, which is binding the other company to European data protection standards. So that second point is about making sure you understand where they're processing their data, and if it's outside the EU, that they've got the appropriate checks and balances in place, and that you're happy that they're compliant in that regard. The third contractual obligation is that they've basically put in place adequate organizational and technical the personnel, from an organizational point of view, they've put in appropriate training and understanding in their employees that, this is not their data, it's not the company's data, it's their customers' data, and that they therefore have to abide by duties of confidentiality and apply data protection law. And that ties into the next bullet, which is the requirement that the processor must basically ensure that they've got everything technically and organizationally in place to make sure that all processing that they do of your data is indeed secure. All processing of data, personal data, has to be done securely, and your data processors are no less required to have security in place than you are. The next one, they have to make sure that they ask you before they engage with sub-processors. So a sub-processor would be the data processor using a further party to actually do the processing, or an element of the processing for you. So for example, you might use a third-party cloud-based service and you're processing your data using that service. That makes that service your data processor, but they actually store your data on Amazon Web Services servers, which makes Amazon Web Services servers a sub-processor, because they are processing the data by the mere fact that they're storing it. And whilst the data processor have all these requirements in terms of security, et cetera, in place, they have to make sure that they apply those same rules to their sub-processors. They should ask your permission, but I mean, typically what you'll see is in the data agreements, it say we will use a standard set of sub-processors, and they should really hopefully list what those sub-processors are, so you can see. But if they change their mind or change a sub-processor or introduce somebody else, then they need to ask your permission, and that might be that you know, just like you get emails saying we've updated our privacy policy, you'll get emails saying we've updated our terms of services, and we'd like to draw you to the attention that we've added some new sub-processes or removed them. You've got 21 days to tell us if you wish to object. But the same rules that apply to between you and the data processor also have to apply between the data processor or your data processor and any sub-processors they use, and you want to basically tie them down to accepting responsibility and liability for miss or non-compliance by the sub-processors, because you don't want to get caught out if the data processor has missed something with the sub-processor. You also need to make sure you've got a contractual term in there to make sure that the data processor will assist you as the data controller with your obligations, particularly dealing with individuals' rights, so things like subject access requests, and also other obligations relating to things like security, how you deal with breaches, how you deal with data protection impact assessments, and so on. So they need to be able to help you basically carry out your obligations of compliance under GDPR. You have to be clear about the terms of what happens when you finish the service. So will they delete the data straight away? Will you know, can you tell them that you want the data back once you've finished, etc. And then finally, probably, as if you're a data processor, probably the worst clause of them all, which is that the data controller has the right to basically get you as a data processor to demonstrate that you're compliant, and that includes contributing or allowing a controller to carry out some kind of audit and inspection. So you could ask somebody to act as your auditor and go in and audit your data processors. Now, in reality, if you're using some of the household names, you're not likely to be able to turn up at Microsoft's offices or Google's and start auditing them, because they're probably not going to let you do that, except in very specific circumstances. But for everyday business users, it's unlikely you'll be able to do that. But what Google and the Microsofts of the world are likely to do is probably be able to show you, look, we had an independent auditor in, and this is their report, and there's a duty on them to maintain that and be able to constantly demonstrate that they've got that compliance. But you know, if you're using a local marketing company to do your marketing and you supply them with your email list, you have a right to send somebody in to carry out an audit to make sure that they really are standing by these terms in the contract, and also that all the things that you ask them about from a due diligence point of view are actually true. So quite onerous on the data processor. And I'll touch about this a little bit more in a second, but essentially those are the contractual terms that need to be in place, and they are specifically documented in the GDPR, so there's no escaping the fact that those have to be in place. Just a word of caution, I've seen from some controller processor agreements that some, you know, depending on which side of the fence you are, if you're the processor, you want to make sure the terms are as much in your favor as they are the controllers. If you're the controller, you don't want to see onerous terms put upon you, and equally you want things to be in your favor rather than theirs. But I have seen things like people saying, you know, yes, you can come and do an audit, but it will be at your expense, or yes, we will help you with the data protection impact assessment, but it will be at your expense. Those kind of things, the expense element of it isn't dictated by GDPR, so that's down to where you see you want to fit. You know, if you're happy to say we need you to help us answer some questions about your service for a data protection impact assessment, then and pay for that, then that's fine. But if you know that I do have clients say to me, well, do I need to pay for this to happen? Is this an obligation? And so on. And the answer to that is there are specific obligations in that you've got to be able to do it, but the terms of that, so things like cost and regularity and all those kind of things, that's between you and the data processor. They're not dictated by the regulation per se. Yeah, so those are the contractual terms. That's what the law says you have to have. Those need to be in some kind of agreement or contract or whatever you need. And as I say, that might be you as a controller saying, here are my terms for using your service. Here's my data processing agreement. Please sign this. Or in a lot of cases, particularly online services, they will have a data processing agreement or terms of service that you're signing up to, which have these embedded within the conditions of service. that's not the end of it, because there's much more you need to do, particularly if you think about the bigger picture and the requirements to demonstrate that you're still compliant today as you were 6 months ago or yesterday or when you did your GDPR audit at the beginning of 2018 or whatever. You still need to be able to manage your ongoing compliance. I think there's a slight sort of reticence to appreciate that GDPR wasn't just about the 25th of May 2018, that it's as relevant today in 2019 as it was on the 26th of May last year, as it was at the end of last year, and it will continue to be relevant until the law changes. And in the UK, Brexit might make the law change in some ways, but generally speaking, data protection's been here for the last 20 years. The GDPR updated it last year. It's going to be here for ever and a day. It just what it looks like in terms of some of the detail may change over time, as we saw when the GDPR was introduced last year. So you need to be able to demonstrate you're still compliant. And there are certain elements of the GDPR that talk about the need for regular reviews, and the ICO themselves, our Regulated Information Commissioner's Office, has indicated through some of the research it's done working with organisations that one of the key things that lots of organisations forget is that they are not reviewing at regular intervals their compliance still being basically applied across their organisation, whether that's training staff, whether that's reviewing policies, or whether that's actually carrying out internal audits to see that people are paying attention and are deleting data when they don't need it, or that that they've got the right consents for marketing and all that kind of thing. All of that needs to be carried out on a regular basis. What that regularity may be will vary depending on organisation to organisation, but I'd suggest probably at least once a year. So, if you are, as far as you're concerned, compliant because you did the GDPR stuff last year, this year you should be thinking about how do we make sure that we are still compliant. So there's an element of regularly reviewing your compliance. Now, when it comes to third-party processes, you're going to have to think about, well, is the due diligence need reviewing? Are our third-party processes still compliant? Has something happened in the news that has indicated that they're maybe not as secure as we thought they were? They've had a massive breach or whatever. You will need to pay attention to all of these things to make sure that they don't impact on you and that they don't impact on that contractual relationship as well. But one of the other key things that you need to do is make sure, particularly if you're in a large organisation with lots of employees who have lots of good ideas about different services and processes they might be using, that they understand the importance that they can't just suddenly start putting personal data on a service without somebody carrying out these due diligence checks and making sure there's a data processing agreement or contract in place. So you need to educate your employees, be that through training, be that through regular briefings, be that through having posters in the staff room or whatever. You need to make sure that your employees across the whole of your business are on board, because you just need one employee to stick some data on a service which isn't secure and gets a data breach, and you've not got terms of service in place. You're not able to demonstrate that you've checked them and carried out due diligence, because maybe if you're the data protection champion or officer in your organisation, nobody told you that the organisation was using this service. That's where you're going to get caught out if you were audited, or if something happens and the ICO start asking questions. So make sure your employees are on board. Review the compliance, and that includes the due diligence. So there's compliance in general, but due diligence for third-party processes on a regular basis. I'd suggest at least have a sort of a quick look over where you're at and making sure you've got everybody's up to speed with making sure that you've got everything documented in terms of who your processes are and that that's still relevant. Make sure you do that on a regular basis, probably once a year. Keep an eye out for any changes in terms of service that might happen with these services, where they might adjust some of the contractual elements of the data processing agreement, or if something you hear about in the news that there's been a breach or the service has gone bankrupt, or what's going to happen with your data, all those kind of things. Now, remember that last, so I'm on the blue spot on this slide, remember that last line in that contract, which was that you as a controller should be able to basically get the processor to demonstrate their compliance, either by providing you with evidence that they've carried out audits and that they are above board, or that you could even send somebody in to carry out an audit and they would have to assist. Well, we're not clear because the guidance isn't particularly clear about how that should be enforced. So the fact that you're putting that in place in a contract is one thing, but should you be making use of that? Is there a need for you to actually think, do I need to ask for evidence that they are compliant? So are they carrying out audits once a year, and can they send us an audit report, either independent or internally, depending on the circumstances? Are they publishing stuff annually on their website to give you up-to-date checks and balances that they've carried out and all that kind of thing? So again, going back to that last point, the last couple of points, just keeping an eye on what changes you might need to, sorry, it's the red spot on that circular set of spots. Is if there may be guidance or other things that happen from the regulators across Europe, or something that might happen in terms of an enforcement, which might lead you to do some more about what this auditing is. And I know from working with various organisations that they are seeing quite strict expectations of their controllers. So these are clients that are processors around these auditing terms. And so, you need to think about what that means to your organisation, and how can you demonstrate that you are convinced that your processors are compliant. And that's documenting the controller processor due diligence and the where your terms of service are, or the data processing agreements. But all equally, think about whether there's people out there that you, or organisations that your data processors, that you might want to consider. How do you enforce that auditing clause in the data processing agreement? Because it might be something that you ought to consider as part of being able to demonstrate that you are indeed compliant. I don't think anybody can do anything these days without mentioning the B word, Brexit. Brexit could have impacts on data flows in between the UK and Europe. So if you're processing data of European citizens, when we leave Europe, there may be some implications that might impact on data flow and data protection law, particularly if there's a no-deal Brexit. If that's something that you'd like to know a bit more about, if you go to digitalcompliancehub.co.uk, my website, and have a look, there's a blog post about the sort of a summary of that. And I'm also holding a webinar in a couple of weeks' time as well. But you'll need to pay attention to what Brexit means generally, but also that might have an implication if you're using processors in Europe, and suddenly you're there and we're outside of Europe. What does the UK law say? Well, probably the UK law is going to say, well, you can transfer data to Europe and not worry about it. But it might not be that simple. Yeah, so ongoing compliance, you carried out your due diligence if indeed you've been doing it. If you're on this webinar to find out what you ought to be doing, then you need to bear all these things in mind now. But even if you've done it already, you've got to have to consider what ongoing compliance in this particular area looks like. And of course, that needs to be part of a bigger ongoing compliance project across your organisation for data protection in general, because obviously this is just one element of GDPR compliance. So what does this mean if you're a data processor? Well, you're on the other side of the, the shoes on the other foot, or you're on the other side of the fence, or whatever metaphor you want to use. But there are implications, of course, if you're a data processor. So if you're looking at this and thinking, well, I'm a data processor, what does this actually mean for me? Well, you need to make sure you've got a good, clear position on your GDPR compliance, because your clients are going to be asking you about it. And as I said, some clients are now asking and expecting you to demonstrate that you are carrying out audits on a regular basis. And I've even seen terms in agreements that require you to carry out certain types of auditing. So you might find this with particularly large clients, that they will be dictating a lot of those contractual terms in a lot of detail, and they may be exercising the rights to expect you to demonstrate that compliance as well. So get a statement out there. Don't be shy about explaining how you are GDPR compliant. It's in your own interest to do it for yourself, because it goes towards you demonstrating your compliance. It goes a long way in demonstrating to potential customers that they don't need to worry with you processing their data, because you can be trusted with GDPR, and they don't need to ask you lots of questions and try and force it out of you, because you're open and transparent about it. So have a position, make a GDPR statement, be open upfront about your compliance, and be proud that you are compliant, because that's a good selling point for your business, let alone the fact that you're going to need to do it, because they should be asking you these questions anyway. And expect them to be checking you out and checking that you've got your compliance in place. you may want to consider having your own data processing agreements. If you're serving lots of data controllers, then it's probably in your own interest to have a data processing agreement of your own, which you ask them to sign rather than be dictated by their terms. Sometimes it doesn't work that way, but it's a good place to be, where you can say, well, look, we are compliant. We've even got a terms of service that covers the data protection requirements, and by using our service, you're signing up to these. These meet all the requirements of Article 28 and so on. Prepare for those stricter compliance checks that might be coming. 2019 will be the year after GDPR came into force, and that's the prime time that people are going to start thinking about how do we demonstrate our ongoing compliance. So, like I said, you might need to demonstrate that you're carrying out audits, have something documented in hand to show that you're compliant. And as that first point I was saying about, if you shout about it, then that's got to be a good thing for your business in general, let alone appeasing your current customers. But don't forget your own responsibilities and liabilities. Unlike old data protection, so our old 1998 Act, under GDPR, you can be held responsible and liable for data breaches and other elements of non-compliance. So it's not now just down to the controller to get it right. You've got to get it right as well. And it's not just for this controller-processor relationship. You can be found liable if you're not compliant as well. So make sure you understand what those responsibilities and liabilities mean to you. And of course, just as I was saying with the controllers, you've got to maintain and manage your ongoing compliance as well. So keep your compliance up to date. So that was a pretty top level summary of what the controller processor requirements are. From a controller processor relationship point of view, the key things are processors have to be GDPR compliant, otherwise the controllers can't use them. Controllers should be carrying out checks to make sure they are compliant, and that those checks should form some part of some documentation or register that enables you to demonstrate your compliance. And secondly, you've got an obligation and a requirement by law to have contracts in place between the controller and the processor, and the terms of those contracts are dictated by the law. So you don't have to guess at what needs to be in there. You just need to make sure that you've got those in place and that both parties have agreed to them. If you're a processor, then you want to look at it from your point of view about how to limit your liabilities, how you limit your responsibilities to your data controllers. But I'd suggest being open and transparent as much as you possibly can. So we've covered the controller-processor relationship in terms of the basics that you need to understand, and that was the point of this webinar. If you're looking for some help and assistance, if you want to know a bit more detail, or you've got some challenges, you're being challenged by data processing agreements that require you to do certain things and to agree to certain things, or if you're worried about how you maintain your ongoing compliance, then that's where I can come in and where my Digital Compliance Hub support service can help. So Digital Compliance Hub is basically a cost-effective way of getting help and support when you need it with your data protection compliance in general. We provide guides, walkthroughs, checklists, toolkits. We run sessions like these. Sometimes they're paid workshops, but they're free for Hub subscribers. For example, there's a privacy and marketing one coming up on the 22nd of February, free to Hub subscribers, 125 plus VAT for non-Hub subscribers. We push out alerts and updates so people get an idea of what's happening in the data protection thing, so you don't have to worry about trying to keep a track of what's going on with the ICO in terms of its enforcement and those kind of things. But the key thing is you get access to email and phone support, all part of the service, unlimited email, unlimited phone support. If you've got a particular issue, whether you need help in understanding a data processing agreement, whether you want to get access to a data processing agreement template that you want to be able to adjust to fit what you want to put in place with your data processors, or vice versa, it's all there in the hub. Think of it as an alternative to using the ICO to get some answers, because not least of all, you'll get some straight answers from us and practical and simple solutions to your particular problems, and even you'll even get an hour's worth of consultancy out of the Hub subscription, so we can talk about some of the key things that you might be impacted by, and hopefully the tools are there in the Hub to help you get that compliance in place. Now, when it comes to control and processors, we've got a section around control and processor relationship. There's got the guides, the sort of the basics around what this is all about, which is kind of what we've covered in this webinar. But it's got interactive checklists, FAQs, it's got data processing agreement templates. There's a compliance kit where you can download and basically has everything all in one great big lump, although it's in the hub anyway. Infographics, posters you can share with your staff to make sure that they understand their requirements and responsibilities, and so on. Check it out at digitalcompliancehub.co.uk. There's a 14-day free trial which you can have a look around. Not all of the content and the support services are available in that trial period, but after the trial period has ended, you'll get access to the templates. We can have that hour-long discussion, compliance consultancy, whatever you want to call it, to sort of understand what it is that you're trying to achieve, and I can explain how the hub can help you and also give you some pointers if you're stuck. But the support and help via email and phone, the helpline is there for you to use. Yeah, so check that out. Now, if you've got any questions, there's a questions panel in the GoToWebinar toolbar. I'm trying to get my words out. If you post your questions there, then I'll pick those up and answer those now. Otherwise, thank you very much for listening.